Good afternoon to you all. As you have seen, my topic is compliance with court orders by the executive. In a democracy, compliance with court orders is a normative value. The rule of law practically demands it. People cannot be equal before the law unless state conduct, and not merely the conduct of private citizens, is subject to legal constraints. When the state chooses to ignore these legal constraints, dire consequences follow. The courts are thrown into disrepute. The state is free to engage in wrongful acts, and ordinary people are forced to contend with the woeful results. Perhaps the most significant consequence is constitutional. The constitutional right of access to justice is entrenched differently in different jurisdictions. In South Africa, for example, Section 34 of our Constitution states that everyone has the right to have any dispute that can be resolved by the application of law, decided in a fair public hearing before a court, or where appropriate, another independent and impartial tribunal or forum. In the United States, the Sixth Amendment states that any accused person has the right to a speedy and public trial by an impartial jury, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. The Fifth Amendment additionally protects against double jeopardy and self-incrimination, whilst also guaranteeing every person the due process of law. In each case, the Constitution seeks to protect the public's right to a fair hearing before a fair arbiter. When the state disregards the outcome of that hearing, however, the right becomes meaningless. To ignore a court order is to eviscerate the constitutional right to fair legal proceedings. It is to render nugatory the very notion of access to justice. Stable democracies take compliance with court orders by the executive and legislature for granted. It is unimaginable that orders may be disregarded by politicians. However, in some countries, non-compliance with orders issued by the judiciary is quite commonplace. To mention but two examples, recently there have been instances of non-compliance with or thwarting the efficacy of court orders in Turkey and Poland. This by downright refusal to comply, or stratagems whose ultimate effect is non-compliance. Of course, there are a few other examples in other jurisdictions the world over. In some jurisdictions, there's what I would call sham compliance. To illustrate this, one of my students here, who comes from Uganda, told me that told the class that in politically sensitive issues, the executive tells the courts how to decide matters. Or worse still, a judgment is prepared by the executive's own legal advisors, forwarded to judges for signature and hand down. Obviously then, in those circumstances, the government will comply because the judgment is either at its behest or it is its own judgment. So that is why I say in instances like those, it would be sham compliance. Happily, South Africa has enjoyed a very strong record of executive compliance with court orders. Some might cite as an exception the state's attitude toward the order issued by the Gauteng Division of the High Court Pretoria in the matter in respect of which the applicant was seeking a mandamus for the arrest of President Omar al-Bashir of Sudan, who is facing criminal charges before the International Criminal Court and against whom an international warrant of arrest has been issued. As the matter, and perhaps very fortunately for me, is now on appeal before us, I will not have to comment on that one any further. For me, the best measure for state compliance with court orders is not in what I would call ordinary run-of-the-mill cases. It is on how the state reacts in instances where it, in particular the executive, would be having particularly strong views about the litigation and therefore the outcome. On that test, South Africa's record is cause for celebration. There are a few examples to demonstrate this. One that is notable is the Treatment Action Campaign number 2. Treatment Action Campaign, a non-governmental organization that advocated for the rights of people living with HIV/AIDS, challenged the government's policy on preventing mother-to-child transmission of HIV. At that time, the policy entailed a single dose of antiretroviral medication for HIV-positive pregnant women in limited pilot sites within South Africa. Very, very few throughout the entire country. Few sites. Contending that this was utterly inadequate, the Treatment Action Campaign argued that Section 27 of the Constitution, which guarantees the right to have access to health care services, required the government to implement a comprehensive policy. The court agreed, ordering the state to immediately provide antiretroviral drugs to HIV-positive pregnant women on a comprehensive basis throughout South Africa. But wherein lies the significance that I am laying? What made the case so singular was the stance of the then president, President Thabo Mbeki. President Mbeki's views on HIV/AIDS are now common knowledge. He questioned the link between HIV and AIDS, publicly endorsed the views of dissident scientists who denied that HIV caused AIDS, a position overwhelmingly rejected by the international scientific community, and he denounced antiretroviral drugs as poisons, again following these views of the dissidents. He fiercely opposed their rollout, but when the court ordered the Minister of Health to begin providing antiretroviral drugs free of charge throughout the country, the executive complied. And this despite President Mbeki's strongly held views. Another encouraging example of executive compliance can be found in Blue Moonlight. But I must explain, in respect of this judgment, that the government entity involved wasn't the executive in the sense that we understand that concept. It was the city of Johannesburg, which is at what we call in South Africa the local level of government. We have 3 tiers of government: national, provincial, and local government. Local government being municipalities. I don't know what they are in India. Is it counties? Yeah. Oh, yeah. So it was a case against the city of Johannesburg. The owner of a private property in inner city Johannesburg sought to evict various unlawful occupiers. The occupiers joined the city of Johannesburg in the proceedings, challenging the constitutionality of the city's housing policy for failing to provide them with emergency shelter. The Constitutional Court held that the property owner could evict if doing so was just and equitable, but only if the City of Johannesburg provided the occupiers with temporary emergency shelter prior to the eviction of the occupiers. Part of the city's resistance to the litigation was that although it had a housing budget, that budget did not provide for temporary emergency shelter. In effect, the court told the city to budget in a particular way. I'm sure for constitutional lawyers, the reaction will immediately be, but what about separation of powers? Is budgeting, to start off with, not a policy matter? Then, let alone going so far as to say budget in a particular manner. It immediately raises a very serious separation of powers issues. But the Constitutional Court said it nonetheless. And that notwithstanding, the city complied. Yes, I did emphasize that this one involved the city and not so much the executive, but point of the matter is all of the money in South Africa comes from one pot. It comes from national government, therefore it comes from the executive. So in a manner of speaking, there was a connection with the executive. So if the executive in South Africa was not disposed to compliance with court orders, it could easily have said, city, even though you are another or a different tier of government, do not comply. They didn't say so. There was compliance with that order as well. The most recent example, all of you know about it by now. It has been mentioned all the time. It was mentioned even yesterday, mentioned today, but I will touch on it again one more time. That is the matter of the economic freedom fighters versus the Speaker of the National Assembly. President Jacob Zuma had for 2 years refused to comply with the Public Protector's directive to repay state funds used for upgrades to his private residence. The Constitutional Court held that the President's conduct amounted to a failure to, open quote, uphold, defend, and respect, close quote, the Constitution as required by Section 83B of the South African Constitution. That is a very serious charge. It triggered a media firestorm at home and abroad. It prompted opposition politicians to launch impeachment proceedings in Parliament. It has become the impetus for a new civil society movement to oust the President from office. Perhaps foreseeing these dramatic consequences, during oral argument, counsel for the President before the Constitutional Court literally pleaded with the court not to make the holding that we eventually made. Of importance for our purposes, once our judgment was out, the President said he welcomed the judgment unreservedly, respected the court's holdings, and would abide by them. And he apologized to the nation for, open quote, the frustration and confusion, close quote, caused by the entire saga. Whether the President in fact complies with the court's order remains to be seen. The National Treasury is required within 60 days of the date of the order to determine the exact amount the President must pay. The court will then signify its approval of the amount. This in accordance with what you call structural orders. Yeah. So we want them to come back. That will help us see that something is indeed happening. So in a manner of speaking, we continue to be in control. Following which the President will have 45 days to repay the amount. As matters stand, disregarding the order is clearly not an option. That, in my view, is something in which South Africans should take pride. That said, it would not be the whole truth, not to mention that on occasion, the judiciary, including the Constitutional Court, has been severely criticized within the country for some of its judgments. That is perfectly understandable in a constitutional democracy. We have the right of freedom of expression entrenched in our Constitution. It is perfectly in order to criticize the court. The main charge is that the judiciary is an undemocratic institution that sets aside policies of democratically elected institutions such as Parliament and the President. This raises a couple of troubling implications. First, it implies that the executive cannot be told how to govern by our courts. Second, it seems to say that judges must leave Parliament alone. Yes, courts must not interfere in that sphere of operation that is a constitutional set-aside for the executive and the legislature. And I think this ties in with something that Professor Klug said earlier. So do not interfere in a set-aside. That, in terms of the Constitution, is the undisputed purview or function of another arm of state. Do not interfere. One cannot question that at all. Otherwise, courts would be breaching the separation of powers doctrine. That said, it is constitutionally a decreed function of courts to test whether within that set aside or that carve out for the other arms, the exercise of powers by those two other arms accords with the Constitution. That now is a set aside for the court. Put differently, courts are the final arbiter on whether executive or legislative power has been exercised in a constitutionally compliant manner. Within those parameters, there is or shouldn't be any cause for complaint. Let me give you a few examples of the criticism or the complaints that have been leveled at the judiciary. In August 2011, ANC Secretary General Mr. Gwede Mantashe charged that the Constitutional Court was being used as an opposition to the government and cited the court's judgment in Glenister as an example. In that matter, the court had held that legislation passed by Parliament did not create a sufficiently independent corruption-fighting body. Then in September 2012, in an article in the Sunday Times, Advocate Mwako Ramahlodi, who is currently a cabinet minister, argued that the supremacy of the Constitution is disempowering the democratically elected government, whose decisions are second-guessed by a judiciary that still remains largely untransformed. Last year, Mr. Stumo Dlamini of the Congress of South African Trade Unions said, "We have seen how our hard-won advances secured since the democratic breakthrough continue to face threats from our own judiciary, which zigzags from making progressive rulings which assert the new democratic dispensation and making rulings that clearly protect apartheid privileges and in many cases constitute judicial overreach and undermine the doctrine of separation of powers. The result of this has been to undermine the majority rule and to impose setbacks on development which favor the majority of South Africans." Last year, the criticism of the judiciary became so incessant that the Chief Justice determined that a formal response was necessary, something unprecedented in South Africa. He requested to meet with President Jacob Zuma. The purpose of the meeting was to discuss the dangers of the repeated and, at times, if not at most times, unfounded criticism of the judiciary. At an unprecedented press conference before the meeting that the Chief Justice was asking for, the Chief Justice reiterated that, quote, judges like others should be susceptible to constructive criticism. However, in this regard, the criticism should be fair and in good faith. Importantly, the criticism should be specific and clear. General gratuitous criticism is unacceptable, close quote. One of the judiciary's concerns was that courts only speak through their judgments, which often do not receive wide publicity. As such, courts are unable to counter the negative criticism directly. According to the Chief Justice, criticism of that kind, which is also continuously in the public domain, has the potential to delegitimize the courts. Courts serve a public purpose and should not be undermined. If courts were delegitimized, that would have disastrous consequences for South Africa's democracy. The meeting took place on 27 August 2015, and it yielded inter alia the following resolutions. A, to respect the doctrine of separation of powers and the integrity of the judiciary and executive. B, to exercise care and caution with regards to public statements and pronouncements criticizing one another. Failure to do so will undermine the global status of the Republic as a bastion of democracy, tolerance, human rights, and the rule of law. And C, in their utterances, to strive to promote the values and ethos of the Constitution so that the arms of state are not seen to be antagonistic towards one another. You will recall that at the center of this criticism of decisions by the judiciary is the assertion that courts are undemocratic institutions. I cannot let that assertion go unchallenged. It is so that, unlike members of the other arms of state, members of the judiciary are not elected. But then the Constitution was brought into being by a directly elected body, the Constitutional Assembly, which was made up of the then two houses of Parliament. That democratically elected body created or sanctioned our present court system with its eyes wide open. The manner of appointment of judges, their powers whose exercise is now a source of much discontent, and their tenure were decided upon democratically by this democratic Constitutional Assembly. Thus, the judiciary is a product of and is central to our democratic enterprise. I am strongly opposed to the notion that it is an undemocratic institution. Yes, you do not elect judges, nor do you appoint them every 4 or 5 years, as is the case with politicians. But to me, that does not alter the proposition that I am making. I made this point for the first time in my second lecture here at Notre Dame, in response to a question that had been asked by one of my students. I think it was in the context of separation of powers, and he was also just raising the issue about, but how do courts which are undemocratic, how can they wield this sort of power? I gave the response that I've just read out to you now. And I said to my students, I had never heard anybody else make this point, and that possibly I was crazy in making it. Well, on the Sunday following that lecture, to my pleasant surprise, Professor Xolela Mancu made that very same point in the Sunday Independent, a newspaper in South Africa. Perhaps I'm not all that crazy after all. Thank you very much.
Being the adjudicator and having to make decisions that they expect others take. The interesting thing is this question about what does it mean for the judiciary to require something to be done when the judiciary, we know, doesn't have an army, doesn't have money, asks the other branches. And I would argue, and I'd love to have your response on this, isn't that the check and the balance on the judiciary? Right? So this is a system of checks and balances that goes both ways. The judiciary is perfectly right to give these orders. That's its job. But at the same time, it has to manage its relationship with the other branches to the extent that it's going to expect them to fulfill it. And I think the example, which all of you are well aware of, is Brown versus Board of Education, is the globally known decision of the US Supreme Court and heralded as such. And the response to it, we don't like to talk about too much. The response was, half of Congress said, we will never follow it. The response was incredible resistance throughout the South to its implementation. And some would argue the response continues to this day as not one that we have perfectly integrated schools in the United States. So this question of how far the judiciary can go and the response to it.
I would say about how far it can go in terms of what it is trying to do. Ultimately, is an interpretive question. It's a question of what does our Constitution say insofar as the powers given by the Constitution to the various arms of government are concerned. If in that interpretative exercise the court is satisfied that if we grant an order of this nature that is perfectly in order in terms of our Constitution, it is acting within its limits. If the order goes as far as our order of the 30th of April did, which had very far-reaching consequences, serious political implications. So it's the what should you say? You know, it's the furthest or one of the furthest possible examples you can think of. So if the court must go that far, but in doing so is still acting within the powers given to it by the Constitution, so be it. It must go that far. The principle of separation of powers in terms of our Constitution does not mean defer to the other two arms of government for the sake of it. Yes, it does, and there are many judgments, as you are aware, that say, you know, deference there, you know, for instance, take the examples of administrative justice, where policy decisions have been taken and they are challenged. So there you are not talking about the invalidity of status or anything, but it's conduct of government organs or people acting under government power whose actions are being challenged before courts. So where, for example, those involve policy decisions, courts will say, we don't make policy. It is the executive that makes policy. So to the extent that we may second guess them, but because it's within the purview of their functions to make policy, we should defer to them. So there is that level of deference in certain contexts, and I'm just giving administrative justice as one example.
There's another example that I remember from the cases, which would be interesting to have your opinion on. That there was a case in which the lower level official had failed to follow an order of the court. And the court's response was to both go back at that individual, but in its order, send a copy to the president informing the president of the fact that a lower official had not followed the report. And that raises for me this issue, which I don't think, I'm not sure how many students are aware of it here, that of course the South African Constitution provides in the Constitution for a form of dialogue between the court and the other branches of government. The way in which the court has sent back or suspended a declaration of invalidity for a period of time to allow the legislature to fix it. That is unknown in the United States, right? But that you see, and that's provided for in the Constitution. So again, you're within your constitutional mandate as you do that.
If I could just add that also what makes it possible for the court in South Africa to make orders that people from other jurisdictions would say, this is unheard of. We have our the remedial powers in the Constitution. There's that catch-all that says the court may make any order it considers just and equitable. So it's
classic common law.
So there's been a series of articles that have been written by Barry Friedman at NYU on the history of this problem in the United States. So we don't think about the problem very often now, but in the early years of our republic, we had many, many examples of this refusal to comply with Supreme Court jurisprudence. And the most famous one, notorious one, it involved Andrew Jackson's refusal to honor the Supreme Court's finding that the Cherokee Nation was sovereign in Georgia, and they could not be removed from Georgia under Georgia law. And Andrew Jackson, who was notorious for his treatment of Indians, said that under no circumstances would he comply with the Supreme Court's decision. The Cherokee Nation was removed physically from Georgia and forced to relocate. So that was a horrible example of a situation where the U.S. Executive branch refused to do anything whatsoever to comply with the ruling of the U.S. Supreme Court. And so we've had our examples from the past that just, and the Trail of Tears, the famous Trail of Tears, that is the story of forcing them to leave, even though the Supreme Court said they had the right to stay. So.
Thank you very much, Justice. I wanted to ask you a question about perhaps our politicians' understanding of a constitutional democracy. There is a belief that sometimes you like to be ruled or believe that your system is like the one that you were under previously. There is a certain level of regression in the debates from politicians. And the regression is to go back to their default position, which is parliamentary sovereignty. So every now and then when the court makes a decision that they don't like, they go back into that kind of mode and get into a huddle. And then start firing all kinds of statements that don't make much sense, including for our president, that he doesn't understand how a court can make a dissenting judgment. That's not so much about parliamentary sovereignty, or not about separation of powers. It's about where we are. Have we matured sufficiently to respect the various facets and understandings of democracy? Would you say that we are a mature democracy with regard to these understandings, or do we regress to the only system of rule we know that we want to preach?
Perhaps I may not answer the question directly about maturity and so on, but say that it may well be that, it's the human element, a self-serving human element. Here's this entity. You have your policies, you have your ideas, you have your programs, and this entity fairly frequently says, you can't do that. So it's a reaction, just a reaction to that, and by somebody who feels antagonized. So there's that for me, and you put your finger on you put your finger on it when you say a rebate to parliamentary sovereignty, because you remember my second example when I cited three examples. Advocate Mokora Matlodi, what he was saying there, even though he did not mention it in so many words, but what he was on about was indeed parliamentary sovereignty. But where would that take us? Where would that take us?
And we decided not to do that.
Yeah.
Sorry, go back and then Jack.
Okay, thank you. I think if I'm not mistaken, currently in South Africa there are around 10 kingdoms that are ruled by kings and that have some sort of autonomy under the constitution. And one way of manifesting their autonomy is, I think, those kings can dispense justice with regards to their subjects. And there was a recent court case, I think, wherein one of the courts in South Africa, it's not a constitutional court, but I don't remember which court exactly it is, but found that one of the kings has like mistreated or committed some sort of crime, and he was sentenced to 12 years. And then I've been following the news, and some South Africans were raising the issue of the autonomy of traditional kingdoms in South Africa, and they were saying that this modern or the courts are interfering with the autonomous right of the kingdom. So I think there's that sort of tension. So my question is, to what extent do these traditional kingdoms and kings have rule over their subjects, and when is the right time for courts to intervene? And was that judgment, I'm sure you are aware of it, was that judgment in contravention of the constitution, or was it in line? Thank you.
What one should always bear in mind is that now, under our constitutional democracy, the constitution is supreme. So it is the constitution that recognizes the institution of traditional leadership, which includes kingship and queenship. And it is the constitution that recognizes customary law, which would be the sort of law applicable to, let me just say, people who are subject to customary law. But in doing that, recognizing traditional leadership, recognizing customary law as a system of law, the Constitution still subjects both those to the Constitution itself. And once it does that, it means customary law is subject to, for example, the Bill of Rights. But of course, the Bill of Rights only goes up to Section 39 of the Constitution. And the Constitution has, I think, 243 sections. So both of those, beyond the Bill of Rights, are also subject to the rest of the provisions of the Constitution. Now, let us look at what the king had been charged with. He had been charged with kidnapping. He had been charged with was convicted of, I may be wrong on the detail of the offenses, but I think it was abduction, then the assault, and I think assault with intent to do grievous bodily harm. He had been convicted of culpable homicide, but fortunately for him, on appeal on that one, he was acquitted. So let's just look at only these two examples. Those would immediately be unconstitutional under the Bill of Rights, just those two examples. So for anybody to say that there is interference with traditional leadership, they are effectively trying to argue against what the Constitution itself says. They should rather say the Constitution is wrong in subjecting traditional leadership and customary law to the Constitution. Then their argument would be understandable. For as long as the Constitution stands as it is, subjecting traditional leadership to it, subjecting customary law to it, the basis of the complaint, in my view, is totally unfounded.
was just wondering whether this whole spectrum of non-compliance with court orders is something which is arising, well, I think in the al-Bashir matter in particular, which is at very high level. Some commentators are suggesting that we're seeing the judicialization of politics in South Africa, in the sense that our political process, our democratic parliamentary process, is a little bit hamstrung because of political circumstance. We have political parties who are not perhaps able to engage in intelligent or constructive debate within other parliamentary or democratic processes. And more what we're seeing are political parties, for example, like the EFF and the DA, using the courts almost as a political weapon to gain points against the president or the ruling party. Do you see that as do you think it's a valid, is your concern for the court? Or do you see that almost as do you think that is an illustration of our democracy working well and a true sort of operation of separation of powers? Or do you perhaps see it as a threat to the institutional legitimacy of the courts? Because I think you get two very different ideas about what the signals, and I was wondering what your thoughts were.
Perhaps I want to look at it by scrutinizing what preponderantly the outcomes in the courts are. And I would say preponderantly, those who take these political issues to court often succeed. Now, if they succeed, it means that the court says there has been non-compliance with the Constitution. Now, if that be the case, why should there be complaints? Because effectively you are saying people, or rather you would be saying people should be content with non-compliance with the Constitution. Is that an option? I don't think it is. So I would understand the complaints if perhaps we were to reach a level where those political complaints are taken to courts fairly frequently and are knocked down each time. Then, that would be clear or incontrovertible evidence that there is indeed an abuse of the court process by politicians for political ends. But thus far, purely on the basis that preponderantly those political complaints succeed. Judge Davis, in fact, was it? I think it was in Mazibuko versus Sulu. The then Speaker of the National Assembly, Justice Davis, at first instance, who heard the matter at first instance, actually made that point. Don't come to us, rush into us, political issues all the time. But in the Constitutional Court, the DA succeeded. Am I wrong? Oh, Ms. Mazibuko succeeded, yeah. Even though, of course, it was not a unanimous decision. But that complaint succeeded before the Constitutional Court, despite how the judge at first instance had viewed the matter.
Hi, my name is Tony Calvano. I was thinking about, first of all, I just want to point out that this is all first impression to me, so I probably don't understand the nuance like everyone in the front of the room does. But it seems to me that having, in regards to separation of powers, having the different political institutions kind of bickering or worrying about their own legitimacy is kind of a symptom of a thriving democracy and not a problem. It's almost a good thing that people are actually worried about that. And it would be as if they contravened that system and just did whatever they wanted, that would be the problem. But the fact that you kind of have an ongoing dialogue seems like a good thing. And I wonder, is that something that you think is just going to take, it's a fairly young democracy, just maybe 50 years from now, you'll take all of these things for granted and people will just settle into a role. Because, I only really know America's history, but in America's history, we still are arguing over what can the Constitution do? What should what should our Congress be doing right now? What's their role? And I think maybe it's spun negatively, but in fact it's actually a positive on the face of it, in light of the entire history of South Africa.
I think I take your point. I think I agree with you that it's not necessarily negative, But as I explained in my short talk here, the court's concern was more that because its power is, only the power of the pen, if these are so incessant that every day the public is bombarded with these negative assertions, and the problem more being that you will find in South Africa, judgment comes out now, 10 minutes, there's already somebody commenting on radio or TV, going on about how wrong the decision is. They have not read even the first paragraph of the judgment. And naturally, what they will be saying will not only be unsubstantiated, but it will be total nonsense, actually. But so now, yes, freedom of expression, but if the criticism is so incessant that because the courts themselves don't get that same exposure that these critics, mainly political critics, have in the public domain, that will end up undermining the judicial authority of the courts, and that may redound to the disadvantage of our constitutional democracy itself. That was more the concern of the Chief Justice when he asked for the meeting. But as I said in beginning to respond to you, I think I do agree with your point.
Please join me in thanking Justice Madlanga.